So I want to talk to you a little bit about business civil litigation. So first of all, what is business civil litigation? It is normally the litigation style that's non-criminal, okay? So nobody can largely go to jail during this process unless there's a contempt, something like that. But traditionally, no jail time is on the table. It's not a criminal action. It is a civil action, okay? And the big core thing about a civil action is that you have no constitutional right to representation when it comes to a business action. Additionally, business entities are seen as a separate and distinct entity than an individual. Vast majority of our cases, it's a business against another business or a business against an individual. An individual can represent themselves in business litigation, but a business cannot. What that means is you can't be the lawyer for your business because you're not a lawyer. So you have to hire an attorney. You're stuck hiring an attorney if you are operating as a business, and if you do not hire an attorney, a default will happen and you will lose the lawsuit. So it's really, really important that you hire a business law firm in order to represent your needs, because you have to have one. If you get a personal injury attorney or a divorce lawyer to represent your business, they can do that, but the quality of the representation just might not be there. So that's what business civil litigation is. So the next thing that you need to consider as a client when you are engaged in a lawsuit right at the very beginning is you need to talk to your attorney. You need to figure out, do you have a strong case? So what goes into that is, the legal merits that you have, any defenses you have, any weaknesses you have, and the evidence required. So you may feel like you have a strong case, but there's an old adage that says there's what you think you can prove and what you can prove. So you need to make sure that you have a good plan of action. You know what causes of action you're going to go for. And you need to know what affirmative defenses there are in order to protect you if you're being sued. So for instance, if there's a contractor, he's going to come do a remodel job at your house, and that remodel job's $100,000, and he puts in the new floor and all of the tiles are puckered up, or they don't have any grout in them and they look horrific, right? And that's the first half of the contract with you. You say, look, you can't come back. This is terrible. I have to get somebody else to come in, fix all of the tiles, and I don't want you doing my cabinets because it's clear you had no idea what you were doing when you did the floors. So that contractor may sue you for $100,000 because you haven't paid him. He only did half the job, but he may in his contract say you owe the full amount if you terminate his contract. Well, that may be what's called an anticipatory breach by you, which means you breached the contract, but you had good cause to do it. I'm not going to pay him money for bad work that he's done, and I have no faith that he could do the future work. But if you hire an attorney that doesn't know anticipatory repudiation, anticipatory breach, so other clauses that we talk about are tortious interference with prospective economic advantage, tortious interference with contract, chattel. There's all sorts of legal jargon that can go into a civil case that if you don't have the right representation and you don't assert those defenses at the very beginning, then you actually lose those defenses. And if you switch to a different counsel down the road, it doesn't matter because you needed to assert some of those defenses at the beginning. So number 3, what is the process for civil litigation? So we always like to start with a demand letter. That's kind of the introduction of the issue. That's where the law firm sends a letter on your behalf and demands some sort of relief, and we set out what under the law we believe that you have broken, why you are liable, and the amount of damages that we believe you are liable for. That gives the other party an opportunity to review the law, review the damages, review the claim, submit it to insurance if necessary, and trying to frame the issues. You can be successful without having to go to civil litigation, which is a very expensive process. But if that fails, you end up filing a complaint You end up conducting discovery, you end up filing motions, usually court-mandated mediation or settlement, and then you end up going to trial. So that process itself is very, very interesting. During COVID, for instance, in a criminal matter, you have a right to a speedy trial. You have no right to a speedy trial in a civil matter. So during COVID, all the criminal cases were being heard. No civil cases were being heard. So those cases got kicked out for years. We're largely through that backlog. So now cases are back on about a 12 to 18 month track. So you have to take all those different phases, divide them up over the 18 months. That's called the court scheduling order. The court will take and put out a scheduling order for when certain things must be heard, decided, etc. So it's important, if you have a good litigation team, that you view that scheduling order. You may be able to put a budget to that scheduling order depending upon the complexity of the matter. And then, the attorney needs to understand what needs to be done during every phase. So we have senior litigators here at Taylor Law offices. Actually, all of our litigation team have conducted trials and been first chair in trials. That's kind of a lost art because about 98% of all cases settle. So it's very rare that things make it all the way through trial, because usually people make the business decision to settle because at some point during all of those phases in that process, everybody knows the law, they know the facts, they know the damages, so they can compute what their risk reward is about going to trial. And oftentimes people will make that decision to settle. So let's kind of talk about what are the costs and the risks. In some civil cases, like personal injury, things are all done on contingent fees. So how much money do you recover? And then out of that gross amount, the law firm takes their money. The costs for depositions, copies, experts, things like that get reduced out of it, and then the client's left with the remaining amount. The vast majority of cases that we do are all hourly. So we bill on an hourly basis, and we have our attorneys that conduct the work and the paralegals that conduct work also in order to get the case done. Now, throughout your case, you'll have a variety of attorneys that come in and assist on that case at different times. Well, why? At Taylor Law offices, we've had certain attorneys that have taken certain types of cases extremely far and even to trial. So we do a lot of injunctive work. So we get non-competes made unenforceable or enforceable, and we ask the court to do that at the very beginning of the case. If one of our attorneys doesn't have a lot of background in that area and another attorney does, he'll come in and help in that instance. It keeps the client fees low because they have that experience. So I have to do as much research, as much prep, etc. And it allows that case to be heard quicker. You also get a better result because of the history, strength, and background of having that co-counsel. That's how we charge for our fee. Then the client, besides paying for the attorney, you also have other costs that you need to consider. Some law firms still charge for copying. So every page that's copied, when you have litigation binders, sometimes you're printing hundreds or thousands of pages of documents in order to prepare. Those are costs. You have filing fees. So it used to just be one fee at the very beginning to start your case. Now certain documents, so every motion you file may cost $6. I think that's the going rate for most of them now. And those add up over time because you file a motion, they file a response, you file a reply, right? They file a surreply or whatever it might be. You may have multiple motions throughout your case, and indeed you will, especially if you go to trial. And then one of the costs that you have to think about is damages. So one of the strategies that we use here at the firm, if you have a smaller case, let's say it's $10,000, and you are 100% in the right and somebody else is going to sue you, and they want $10,000 from you, you may want to settle. And that may sound ridiculous to you. You may have the strongest case on earth, but you may want to write them a check for $5,000 and make them go away. Well, why would we advise you to do that? And there's a saying I have in our office that I've taught the attorneys, and that is the client has two options in cases like that. They can pay you to talk about the problem and stay in the problem. Or two, they can pay the other person and get out of the problem. So it might be that your litigation costs, your hourly rates of us that you have to pay, those motions, the fees, the experts, all of that. Let's say in a case over $10,000, it's $50,000 because there's no difference between a $200,000 case and a $10,000 case as far as the amount of legal work if it's the same underlining facts and law. Sometimes we advise our clients, we go, look, instead of paying us $50,000 in fees, pay them $5,000 in damages and get out of it and take the other $45,000, reinvest it in your company and get back into your company and go make money. We give that kind of advice because it's practical, it's good, but we also don't appreciate shakedowns and things like that. So there are other times that we're definitely going to assert our clients' rights and we're going to move ahead because they may have that same issue too, that they're going to have to put out tens of thousands of dollars to try to prove a $10,000 claim. So strategy comes into play, and pairing strategy with potential costs and potential damages is something that a civil litigation law firm needs to be an expert at. So let's talk about, what instead of those costs, those scary costs that can go into those tens of thousands, hundreds of thousands of dollars, what are some options that you have besides those costs? So one of the first things that you do in that demand letter phase is you're trying to negotiate your damages. You know what the law is, you know what the facts are, or most of the facts. You may argue on damages, but people can agree that there are some. So engaged in good faith early discussions of settlement is a core thing that a business lawyer should do. The most expensive cases that we've ever had are when the attorney on the other side doesn't know what they're talking about. It's really hard to convince stupid. So if a client's really stubborn on the other side, or their attorney doesn't understand the case law, they don't understand how that impacts damages, and you can't engage in good faith discussions over that in the demand letter phase, then you're hell-bent for trial because you can't convince people that don't want to be convinced that they're wrong. And so that's difficult. So sometimes you have to elicit help of a third party. So if I think I'm right and maybe I'm stubborn or I'm headstrong and the other attorney thinks he's right and he's stubborn and he's headstrong, or we both have clients that are stubborn and headstrong, then we get into a process called mediation. Mediation is the process where we hire a third party, usually their current attorney, that has handled the very type of case that you're negotiating before. And that mediator will go room to room and maybe not necessarily say, you're a winner, you're a loser. They won't go into that, but they'll go into, well, why do you think the law supports that damage? Why do you think the law supports that claim? So that mediator will go back and forth between the parties and try to seek a resolution and try to break up the logjam. Maybe have that discussion that I said earlier about, pay to get out of it instead of pay to talk about it. And that mediator can be really good getting the parties to a settlement. And there's a saying when it comes to mediation. You've cut a good mediation deal when both parties feel that they've left something on the table. So a good mediator, if you have a claim and it's $50,000 and the other party says, no, I think I only owe 10 and you think you owe 50 and everybody settles at 25, you paid a little bit more than what you thought you owed and the other person got a little bit less than what they thought they were owed. But at the end of the day, you're able to get a resolution and move on with your life outside of litigation. So that's kind of a win-win, but each party left wanting a little bit more. And that's kind of what mediators try to do. Now, the next process that you can engage in is arbitration. Now, what's the difference between mediation and arbitration? In arbitration, you're hiring an arbitrator, or you'll even have an arbitrator panel, depending upon the amount of controversy. The arbitration is like litigation in that they can have kind of a judge and you're trying more of your case. As far as a mediator, they don't make any rulings. They don't have anything controlling over your case. But an arbitrator can make certain rulings. And if you go through the total arbitration, that's exactly what they'll do, is they'll rule in favor of one of the parties, and you can try to settle the arbitration going down the road. So why arbitration versus trial? Well, in trial, like I said, it may take 18 months, it may take more. Arbitration, it can go a lot faster. Usually the amount of time to try a case in an arbitration versus a trial is less. And sometimes contracts demand arbitration over litigation. And in arbitration, there's not that jury that you can be up against when you are in litigation. Just different alternative ways of resolution that need to be explored. And again, a trial attorney knows all of those different forums. They all have different rules. There are arbitration rules, there are the Idaho rules of civil procedure. You have to know mediators. You get to know them really well because you're in front of them all the time. So you have to know how to write a good mediation statement, right? So that's a skill set that civil litigators have to have in addition to trying a case in court. They have to know how to resolve all of these conflicts in different ways. And that's why, your civil litigators get paid a significant amount of money, is because they have these multiple sets of skills. Okay, so what is the likely outcome? When you work with a good civil litigation team, right? So for instance, at Taylor Law Offices, we've tried and we've handled dozens of the exact same lawsuits. So I can't tell you how many breach of contract lawsuits we've done. It's been in the hundreds, if not more. We do it repeatedly because that's what we're known for. How many business partner disputes have we been in? How many membership disputes between LLC members? How many construction defect cases? Hundreds. Now, if somebody has a surgery that went badly and deep vein thrombosis that resulted in a pulmonary emboli and you needed a medical expert to go in and assert, I don't do those cases personally. So I would refer them to a medical malpractice civil litigation attorney, because that individual knows a lot more about those areas as far as the subject matter, and they have experts in their Rolodex that they can use to give opinions on that. But you want to go with a civil litigation team that has awards, that have settlements, that have mediation results, arbitration results in your area of law that you're looking to hire an attorney. And then, settlement. Again, trying to outline, because cases change throughout that process. So once you've gone through depositions, you may file something called a motion for summary judgment. Depending on what the court rules on that motion for summary judgment, that can change how much you are liable or not liable in the litigation. So for instance, if the court says, and this just happened, I think a couple of weeks ago, the court said the other side in their motion for summary judgment, trying to actually stop ours, their reply to it, failed to certify the declarations and evidence in that motion. So they lost. Even though they had a valid defense, the attorneys didn't present it correctly. And so we won, they lost. Now they didn't have claims that were otherwise, beneficial claims. And so we were able to get that lawsuit settled at a significantly lower amount than before, because we were successful during a stage in that litigation process. So constantly think about litigation, because sometimes people go, oh, I will never settle this. And that's just not a practical thing to think about, because it can change throughout that process. And then the duration, how can you impact the length of a lawsuit? So you have the court scheduling order, but if you move up and you conduct certain actions earlier, there's usually no prohibition against that. Usually you don't want to file a motion for summary judgment out the gate, but you can take depositions out the gate. So there are some things that you can do in order to move that timeline up, put some pressure on the other side through the expense of attorney's fees and the resolution of facts and some other things. But that's why you want to work with a civil litigation team. So you're not just reacting, you're not doing things at the very end, and you're not dragging the case out needlessly. So how can you protect yourself moving forward? You always want to make sure that your operating agreements, partnership agreements, all your contracts, your customer agreements, employment agreements are up to date, have been attorney reviewed, and that you're protected in your worst case scenarios. So if everything goes to hell, think about the worst thing that could happen in your business, and everything goes to hell, how are you going to handle it? And I'd run through that scenario with your attorney. Again, I'm Matthew Taylor. Please consider Taylor Law offices in order to help you with your civil litigation matter.